Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Today is a very satisfying day for XRP holders, in my humble opinion. The SEC filed a document the other day, which I'll summarize at the beginning part of this video in just a moment here. But I want to tell you here right at the outset of the video, because it was such a ridiculous submission in the first place on the part of the SEC, that the judge responded just one day later, just with a one-word response. And that word? Denied. Oh yes, you gotta love that. And I'm not terribly surprised to see a quick turnaround in that, not surprised to see that there was a denial, but it's extra satisfying that there isn't even an explanation from the judge, because it's that absurd that this document was filed in the first place. So I'm going to share with you the specifics of the, well, I'm going to summarize the initial document. I made a whole video about it yesterday, so I'm going to be brief on that part. The two major updates, though, Ripple did respond to that, and then the judge filed that one-word order, denied. So I've got that. I've got perspective from a few different attorneys, including attorney Jeremy Hogan and attorney John Deaton. And also, at the end of this video, I have to share with you a separate update. It's going to simply blow your mind. It has to do with a separate SEC crypto-related lawsuit, the library case, which you may be familiar with, LBRY for short, library. And I'll just tell you this part in the beginning, and then I'll share with you all the specifics. But you may, at this point, be well aware that the SEC's initial claim regarding the Bill Hinman Ethereum free pass speech was that it was his personal opinion. More recently, they just did a complete 180 on that, and the SEC is now actually arguing that the Bill Hinman Ethereum free pass speech is actually the official position of Bill Hinman's division that he worked at back in the day, just a few years ago. The Division of Corporation Finance. Yes, the SEC is actually arguing that it's official position of the SEC. But here's where it gets really, really stupid and ridiculous, and I'm just having a good time enjoying the fact that this is reality because it's that dumb. In a separate case, the library case, the SEC versus library case, they are claiming that the Bill Hinman Ethereum free pass speech is just his personal opinion. So there you go. In the SEC case against Ripple, it's official position of the SEC, but their legal team is arguing that it's actually just Bill Hinman's personal opinion in a separate crypto case that's happening right now simultaneously. Unbelievable, right? Like, every time you think this can't get more stupid and absurd, the SEC's like, hold my beer. Now, I do want to be clear at the outset, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, all up in this bitch. But I make these videos about crypto-related topics just as a hobby, and just for fun, damn it. Alright, so I'm going to be as brief with this first part as possible because I made a whole video about it literally yesterday, but the only parts you really have to know in order for me to proceed in the rest of this to make sense is that there's the library case. The library team, the defendants, the library team had a couple major defenses that they're arguing. One is fair notice defense, which Ripple's also doing in their case, and then there's a selective enforcement. Now, the library's selective enforcement or defense, that got slapped down by the court, right? Now, the selective enforcement defense, different than the fair notice defense. The fair notice defense, the SEC actually never even went against in the library case. They did in the Ripple case, don't know why they didn't in the library case, but they did go after the selective enforcement defense that library is setting forth. So then, after that happened, after the court struck down selective enforcement, the SEC attorneys reported that to the judge in the Ripple case and said, hey, the fact that this happened is just further supports our position that Ripple's fair notice defense has no legs. That's effectively what they were arguing. Now, mind you, these are completely different legal arguments, which is why attorneys in the XRP community observing this were left scratching their heads, and I was reporting on that just yesterday. So the SEC filed that document. I made a video about it yesterday, and then after that video, Ripple replied, and they were equally blown away. And then the judge just bitch smacked it down. So here's a tweet from attorney Jeremy Hogan yesterday on this first point. He wrote, in the library case, library actually asserted a fair notice defense, and not only did it not get stricken, the SEC didn't even try and strike it. So how a trial level court striking a completely different affirmative defense in that case is relevant, I don't understand. In fact, I'm pretty sure that Ripple will do a little legal judo and spin this into a positive for it because the SEC didn't even move to strike the fair notice defense in the library case. Sometimes you don't want to try and throw every case into a pleading. This was one of those times, I think. So that's the part that I reported on yesterday. Now we've got this update from Ripple, and this was shared by attorney James Filan, member of the XRP community. And I don't want to read the whole thing. It's on your screen if you want to read the whole thing, because the first page is the text, and then the second page, it's actually just the signature line and contact information. So I'm only going to read part of this, but again, if you want to pause and read the whole thing, you're welcome to do this. So this is Ripple responding to what the SEC put out. This is so. I love this. And this is from Ripple's attorney Michael Kellogg. The SEC's supposed sir reply is anything but. It only nominally addresses Ripple's sir reply, which pointed out the flaws in the SEC's attempt to introduce in its reply brief a list of enforcement actions as evidence supposedly bearing on Ripple's fair notice defense. Instead, the SEC attempts to introduce a new and irrelevant argument based on a recently decided case. A sir reply is not the place for new material. So pause. Right there, Ripple's attorney is pointing out that procedurally, this isn't even the right spot for the SEC to be doing it. So I don't know, like, these people at the SEC, they don't lawyer, bro. Like, they don't lawyer good, right? They do not lawyer good. So is this their first day on the job? And then additionally, they point out here what was quite obvious to anybody with half a brain, even if you don't have a legal background. Like, I don't have a legal background. It's painfully obvious to me that what they were submitting as relevant to Ripple's fair notice defense had nothing to do with Ripple's fair notice defense. This could not be more obvious, which is why attorneys like Jeremy Hogan yesterday, they were left scratching their head like, Jeremy Hogan, a separate tweet I didn't pull up in this video, but I mentioned it yesterday, even he was like, did I miss something somehow? And then there were other attorneys like, no, there's really nothing else there. So it's like, okay, that's effectively what was communicated, because it is that absurd. Anyway, Ripple's attorney continues now. In any event, the SEC's latest case does not help it. The library decision says nothing about fair notice. In library, the court granted judgment on the pleadings on library's selective enforcement defense. Contrary to the SEC's claim, this defense is not similar to Ripple's fair notice defense. It is much harder to prove and much easier to strike. And I'll just pause to note that attorney Jeremy Hogan pointed that out the other day as well. These are literally, structurally, and even just getting to the nuts and bolts of these specific instances, these defenses are not the same. They are not similar. They are strikingly different. Ripple's attorney proceeds. Indeed, library separately pled a fair notice defense that the SEC did not even ask the court to strike, and which remains pending in that case. The SEC's omission of this fact from its sir reply application is remarkable. So folks, think about this. Not only are they trying to make the argument, the SEC's trying to make the argument that the selective enforcement defense is the same as the fair notice defense, which again, it absolutely obviously is not. Ripple here is pointing out that they're just pretending like in the library case there isn't a fair notice defense. They're just completely omitting that information. Dishonest much? Yeah, I think it's safe to say so. Here's an attorney named Bill within the XRP community who had the following to say on this. The failure of the SEC in its sir reply to mention it has not even applied in the library case to strike library's fair notice defense is diplomatically described by Ripple's lawyers as remarkable. It is in fact misleading the court by omission. Folks, this is what these people are like. They're harming their own case. And you gotta assume, just given the fact that the judge responded with one word to all this, is it safe to at least speculate that perhaps she's not pleased with the SEC asshat attorneys? Can I speculate that? Well, of course I can. It's my channel, damn it, and I do what I want. Here's what attorney John Deaton had to say in response to that, what Bill shared there. He wrote, I teach trial advocacy at a law school. I always tell the students not to lose credibility with the judge or the jury by saying things that aren't true or ignoring the truth. the SEC lawyers took no such class when they went to law school. Ooh, think about that. It's so true, though. This isn't the first instance. Like, this is one of the more obviously egregious instances, a good example of the SEC attorneys behaving like this. But I've seen stuff like this time and again over the course of the last year. They're just completely disingenuous. And it does seem to be the case that they were just trying to pull a fast one on the judge, but these judges are not idiots. They most certainly are not. They've proved that to this point, I think it's safe to say. Then there was, so here's the actual response. This was shared by attorney James Filan, member of the XRP community. It's a 2-page document. So the first page here, it's actually just it's actually, even though, so this comes from the judge, but it's a copy of the part of the SEC filing from the other day, actually. So you go to the second page and you can see this is all that she wrote. Denied. Just one word right there. And then it says so ordered, but that's the case with everything that ultimately gets filed, whether it's lengthy or not. So the one-word response to this, it is just denied. So it says denied, so ordered, and then it's got the date, New York, New York. That's it. From Judge Annalisa Torres. She's like, I ain't got no damn time for this. I ain't got no goddamn time for all this. That's exactly what must have been going through her head, right? Denied, so ordered. So you love to see it. Whew. Unbelievable. These SEC assets, they keep outdoing themselves. It's really impressive to see. It really is impressive to see here. Denied. And so here's what attorney John Deaton had to say about this. The SEC asked to file a sir reply to cite a fellow district court judge's ruling from a different circuit striking an entirely different defense while not striking the substantially similar defense that's in question. The SEC should apologize to her for having to type denied. That is so true. Like, even the fact she had to waste her time reading that nonsense from the SEC and then having it actually type even just one word, that is too much. The SEC absolutely should apologize, but they have no shame, and they shall not. And then there was this, somebody named Patrick shared this and tagged attorney Jeremy Hogan, wrote, waiting for attorney Jeremy Hogan to decipher this like a rap icon. So what he's talking about here is the judge's order of just the word denied, because sometimes these filings from the judge, they can be complex, and so to have somebody with a legal background like attorney Jeremy Hogan decipher some of this and explain what it means in normal lay terms can be very useful. And so in this case, it's obvious that's the joke because it's just one word, but this individual named Patrick said, hey, waiting on Jeremy Hogan to decipher this like a rap icon. And Jeremy Hogan shared this GIF, here I'll let the GIF play, and wrote, Judge B saying, talk to the hand. There you go. Which is good because we couldn't interpret that otherwise, so that's good. Oh, I gotta love this stuff. And now into the next part of this video, which is, I dare I say, at least equally as absurd and ridiculous, dare I say. This comes from the official library account. So again, this is regarding the SEC versus library lawsuit, which reads as follows. This is from just this afternoon. The SEC just said in a verbal argument in our case that they have not asserted that Bitcoin or Ethereum is not a security. They're saying the Hinman speech is his personal opinion. This 2018 speech from William Hinman, SEC's Director of Corporation Finance, deemed Bitcoin and Ethereum not securities, with the SEC asserting in verbal argument today that it is just a personal opinion. They are saying the speech means nothing. And so let's pause to point out, we all in the XRP community understand that it was like Billy Boy Hinman, he was trotted out there to share what is his personal opinion with a little asterisk, just my personal opinion, but he was trotted out into the public at that Yahoo, whatever it's called, Yahoo Financial Summit, whatever the hell it was, June 14, 2018, to present this information. And the intent was clearly to provide market guidance and clarity surrounding Bitcoin and Ethereum specifically. That's obviously the case, and I've explained why that is the case and how it's obviously the case ad nauseum on this channel, so I don't want to do it too much more in this particular video, but it's clearly the case. Now, in the Ripple case, the judge ended up finding that it actually really is just Bill Hinman's personal opinion, so she disagreed with us. Okay. Positives and negatives associated with that. Positive is that we're supposed to get, unless the judge changes his mind, we're supposed to get all of the emails that were shared throughout the SEC with the drafts and any sort of internal communication having to do with what ultimately became that speech, the Bill Hinman Ethereum Free Pass speech. So we get those emails, right? Now on the flip side, had it been found to be official decree from the SEC, then those communications would be privileged and we wouldn't get them. But if there's official guidance and that's it, XRP passes the Bill Hinman Ethereum free pass speech better than Ethereum does. So it would still, even though we wouldn't be privy to those emails, in which kind of would be unfortunate, it's actually big picture. It's, from what I've gathered from the attorneys that speak about this within our community, it seems like it would actually be better and more powerful if it were just declared this official position of the SEC, which is why it gets even more absurd that the SEC has flipped their position to stating that it is the official decree of the Division of Corporation Finance at the SEC. And so they're trying to make this silly distinction as if you can have a few different types of judgments. You could have or let's just say opinions. That's the right word. You can have an opinion from an individual. You can have an opinion from a division within the SEC, and then you can have an opinion from the SEC itself, which is completely absurd. If there's a division at the top of the SEC, and the Division of Corporation Finance certainly is, if that's official decree from that division, then that's official decree from the SEC itself. And Jeremy Hogan made an easy to understand comparison. He cited just the other day that, just imagine if the finance department at Tesla says that our policy is that we're offering 0% interest on Tesla vehicles, all new Tesla vehicles. Is that just the policy of the finance department at Tesla, or is it the policy of Tesla? Well, obviously it's the policy of Tesla. Anybody with half a brain can understand this. The SEC apparently doesn't have half. No, they do. They're smart. They're just bad people and liars. They're not stupid, though. They're definitely not stupid. Now, and they're bad at lawyering, too, so like there's a lot of negatives going on. But I'm not going to call them stupid. I don't think they are. I really don't think they're stupid. They're just not good at lawyering stuff. And they're lying asshats. Anyway, and then the library also wrote, the judge also declined requests from SEC to move back the trial date in SEC versus library. This means the library case is likely to be decided before SEC versus XRP. Now, that's interesting. I haven't seen any of the attorneys note if that would have any sort of implications for the SEC versus Ripple case or for XRP itself, but that would be interesting if this case actually settled first, because there's been so many damn delays in the SEC versus Ripple case. But still, can you freaking believe this? Just the fact that they're arguing simultaneously. The SEC is arguing in one case that the Bill Hinman Ethereum free pass speech is just personal opinion, and at the same time, in a different case, also related to crypto, they're arguing it's official position of the SEC Division of Corporation Finance. Unbelievable, right? Hard to believe, but that is the reality that we live in. It's just shocking and astonishing.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.